Hello.
Hi, Arthur.
Hi.
Hello, everyone. Tsilhqot'in for joining us here. Arthur and I are coming to you from our homelands in the Tsilhqot'in Nation. Right now we're at Kamloops. Thanks for joining us. I believe it is an Idle No More kind of sponsored event. I myself worked with Arthur on my master's thesis project in the Indigenous Governance Master's Program at UVic, and we are continued to work since then on getting our land back. So I'll read a little introduction here about Arthur, and we'll get going on this. So as you've read in the Facebook group, the main purpose of the webinar is to talk about colonization, self-determination, and the need for Indigenous peoples to take a strong stand on our Aboriginal and treaty rights. It's through exercising our Aboriginal and treaty rights that we will be able to reduce and eliminate the systemic impoverishment we have experienced generation after generation under Canadian colonialism. The economic uncertainty and risk that's created by Aboriginal and treaty rights has caused economic institutions and former prime ministers to begin addressing a new relationship with the Indigenous peoples. The federal and provincial governments both realize they have a legal obligation to consult with Indigenous peoples. It is up to us to use that obligation to bring about an end to our existing dependency on the federal and provincial governments. Specifically, this has been brought about because of the landmark Tsilhqot'in decision that came down this summer, and how that is going to inform things moving into the future. And particularly, this was set up to be before the meeting between the British Columbia chiefs and the Premier and her cabinet this coming Thursday, where they'll reveal their response, which has been at long last since the Tsilhqot'in decision came out. So we'll have a presentation here by Arthur. Many of you know him and the work he's done over the years. He's the spokesperson for the Indigenous Network on Economies and Trade, the former chief of Nisconnet Indian Band and chairperson for the Interior Alliance of BC First Nations. He's been a voice of opposition to Canadian government's agenda to extinguish Aboriginal and treaty rights and assimilate Indigenous peoples into Canadian body politic, and has been active locally in the defense of Tsilhqot'in land during the expansion of the Sun Peaks Resort, and at the national level. He's also taken the struggle internationally following the path of his late father, George Emanuel, president of the National Indian Brotherhood and founder of the World Council on Indigenous Peoples. So with that, I'll pass it on to Arthur and his presentation. Once again, Tsilhqot'in for joining us.
Thank you, Ryan. And I guess first I'd like to thank you for taking the time to be a moderator on this event. And I'd just like to welcome all of the people who are joining us here on this webinar. This is my first webinar for me, so hopefully it'll all work out smoothly. And anyways, it's kind of funny just sitting here talking to this computer. But anyways, we'll do our best here. Anyways, I have a PowerPoint that I'm really going to race over because what I'm trying to do with this PowerPoint is to put in context the broader issues that involve us as Indigenous people achieving self-determination. I think a lot of times we sort of domesticate our relationship and look at the Supreme Court of Canada, Parliament, the provincial legislatures, as being the mechanisms that will create the kind of change that we think is needed. But basically, the very federal system itself is a problem, and I'll get into that shortly. So we need to question that, and so I basically see the broader issues that we face having to be dealt with the United Nations and other international-based institutions for us to achieve a real level of self-determination in our territories. Anyways, I have this PowerPoint, and I'd just like them to switch to the first slide. Next slide. Do I see the next slide over here? Oh yeah, okay. This is just a quick sort of picture of values that when we're talking about Eurocentric values and Indigenous North American-based values, the Indigenous North American-based values are basically in a circle where we basically look at land, water, air, plants, everything as equal in and around the circle, and if you damage one area, it'll actually come back and hurt you. The Eurocentric concept is more like a pyramid where they look at the resource. The land is a resource, and that you put it into production, and you make some money out of it. You produce some garbage, and in the end, it's really money that is the ultimate goal. Profit is the main thing. So there's these two converging points of view. And it's important to understand this because when we're talking about what is the contribution, the long-term contribution that Indigenous people can make to the economy of this country, it's by reensuring that we're going to have a sustainable economy, something that is going to preserve salmon or preserve moose or deer, trees into the future. And when you look at the Mount Poly spill here in Tsilhqot'in, where they dump tons of mercury into the Quinaul and Fraser River system, you can see that the profit side can really take a pretty swift, irreparable kind of damage to disaster to Indigenous territory. So these are the general outlines. I just want to say that though that thinking is behind in my mind when I'm talking about this economy stuff. Anyways, next slide. Next slide. Anyways, this is a scary picture, anyways, for Indigenous people. It's actually a picture of Stephen Harper, I think, and where he basically was trying to say in 2009 that we have no history of colonialism. And I think you need to understand what colonialism is, because him, by saying that, really means that he is really insulting the human value of Indigenous people, that he really doesn't even care that we exist as people. And I think when you listen to Russ Dibo and his termination policy, you know that's generally the deep-seated sentiment of the Canadian government. Anyways, next slide. Anyways, this is just a picture of the fact that Europeans' values came to our territory by boat. You know. Anyways, next slide. And then the real issue of colonialism that you really need to understand is that it really has three basic concepts. Because I hear a lot of young people talk about colonialism, but colonialism is really three things. It's dispossession, it's dependency, and it's oppression. You know, the dispossession impoverishes us as Indigenous people, and once they take the land, then you become dependent on the people who are colonizing you, and that's the Department of Indian Affairs, the National Health and Welfare, all of those programs and services that our Indian bands are forced to have to accept just in order to exist in this modern world. But one of the things is, and if you fight back, you know, like we did at Sun Peaks, or as they did at Tsilhqot'in, or they did at Oka or Gussison Lake, whenever you fight back, the RCMP, the Ontario Provincial Police, or the Tsilhqot'in, like in Barrier Lake, or the Army are called in to oppress you. So it's steal the land, make you dependent, and oppress you. Russ calls that basically the termination policy. You know, it's basically Indian reserves are set up as holding grounds for Indigenous people to actually either die off or get assimilated, and that's what termination means. And colonization, though, this is what you really need to understand as Indigenous people. Colonization has been condemned in all its manifestations throughout the world. The only place it really is persistent is here in the Canadian context, in relationship to Indigenous people, where we're still being colonized. And the reason colonization has been condemned globally is because it's against world peace. Because the moment that you dispossess people, the moment you make them dependent on you, and the moment you start oppressing them, then you create the urge within those colonized people to fight for freedom and to fight for independence, because they don't want to be dependent. They don't want to be under somebody else's rule. And so that's what is against world peace, is that people who colonize other people generate the environment where basically there will be a struggle for freedom. And that's what we're talking about here today. We're talking about the dispossession, dependency, and oppression, and how can we fight it back within the Canadian context. But you need to understand what colonization is to begin, because that's the real culprit that we're trying to fight, because self-determination is the remedy for colonization. Anyways, the next slide. How colonization happened. This slide's a little bit askew here on my side, anyways. But anyways, colonization happened through the British North America Act of 1867. And you say, what is that, the British North America Act? But actually, that was the first Constitution of Canada in 1867. That's where the British Crown gave all Aboriginal and treaty lands to the federal and provincial government. Under Section 91, the federal government got all the federal Crown lands, and the provinces got all the provincial Crown lands, and which is all our land. You know, so the decisions with regard to our Aboriginal and treaty territories are either made in Ottawa or in the provincial capital in our area. That's colonization. That is, the British North America Act is a direct violation to the human rights of Indigenous people in this country. And that is what all lawyers and all legal systems all stand up, is for that distribution of power. And if you take a look at the if you take a look at the Nisga'a Agreement, for instance, where they signed the treaty, they agreed to that framework. And all the modern treaties, so-called modern treaties in BC, is that they agreed to the 91-92 breakdown, which is that what you're doing is you're entrenching the colonization of your people. Because, and when you really boil it down, next slide, when you really boil it down, this map basically shows you that in Canada, if you add up all the Indian reserves, all we have is, when you total them all up, all we have is 0.2% of the land. That's when you add them up, all the Indian reserves, that's all we have is 0.2. And so we add up all what the federal and provincial Crown has in terms of everything from Crown land to private land that they issue fee simple on. All of that, they have 99.8% of the land, you know. And next slide. And that's why we're poor, you know. According to the United Nations Human Development Index, Canada at this time was at level 1, and then Indians on the Indian Reserve were at level 78. You know, that's because we have 0.2% of the land and they got 99.8% of the land. You know, anytime, you have any dollar from resources developed, for instance, they get 99.8% of the dollar and you get 0.2% of the dollar. That's why we're poor. You know, like the thing is that all the money that the federal government spends on Indian people in this country just puts us at level 78. So I don't know the rednecks when they're trying to say that they're supporting us, because if they're supporting us, we're not at the same level. This 78 is the level we're talking about. Anyways, next slide. We fought against when Canada wanted to patriate their constitution. The Union of BC Indian Chiefs initiated the Constitution Express, which was a train that went from Vancouver to Ottawa in 1980. Next slide. And this is a picture of the, next slide. This is the picture of the Constitution Express. And the reason I'm showing you this is I want to show you the grassroots people. But we don't have a picture of them, eh? Do you have a picture of them? Oh, yeah, there, yeah. The grassroots people can actually really make a change. And I don't know if you understand this, but when you have people, grassroots people, making changes like they did, because I can tell you right now that it wasn't lawyers, it wasn't the AFN, it wasn't any of those people that got Section 35(1) in the Constitution. It was these grassroots people that actually got that in there, because before that, Indigenous people were a non-entity in terms of this discussion. It was because of that train that it created the awareness both amongst Indigenous people, but also amongst non-Indigenous people. I know I was in Ottawa at the time when that train came in, and the whole city of Ottawa, the mayor and everybody, they all got in and actually billeted the people from the train. They were really well organized, but they really supported Indigenous people be able to take a stand on this issue. Anyways, next slide. And this is basically what resulted in terms of the constitutional framework. You wind up with Section 35 now. So it isn't just federal and provincial governments that have sole-making, decision-making authority. It's because the treaty rights of the Aboriginal peoples of Canada are hereby recognized. And so it provides us with the opportunity to have Aboriginal title recognized on the ground. That's what happened in the Tsilhqot'in cases, that's recognized on the ground. And this is how come the Premier has to meet with the Indian chiefs and the First Nation Leadership Council, is because of this new relationship. Anyways, next slide. The other thing that Indigenous people need to realize, and a lot of the establishment organizations don't go this far. A lot of us, and a lot of lawyers don't go this far either. A lot of lawyers, they just talk about the fact that we got our rights recognized under Section 35(1), but they never talk about Section 37. Then Section 37 of the Constitution, for those old enough who might remember, was when we had 4 constitutional conferences in Canada to try and define what Section 35 meant. And those conferences failed. There was no question about it. Like the AFN was involved. I know the first, I think Bill Wilson and a bunch of people were key speakers at Canadian for Indigenous people. But in the end, the final result was that no agreement was made with the Indian people, and basically the Prime Minister at that time said that they would leave it up to the courts to decide whether or not what Section 35 meant, and that's basically where we're at right now. And I think that's totally wrong. I think Section 35, because they failed, opened up the door for us to go to the international level to seek self-determination under Article 1 of the International Covenant on Civil and Political Rights. And I'll get around to that shortly. Anyway, so next slide. Basically, what we're talking about in terms of proprietary interests, and I know some of the questions are related to this when the Supreme Court deals with this issue of radical title. I actually believe that radical title is Aboriginal and Treaty Rights. It's the underlying title of all land. Basically, the way the Crown and the way that the Tsilhqot'in case says, talks about radical title, they try to say that that when Canada asserted European sovereignty over British Columbia, that created radical title for the provincial government. And I totally disagree with that, because if it really created radical title, then it would have extinguished Aboriginal title. But it never extinguished Aboriginal title. That's how they are forced to legitimately and legally recognize that Aboriginal title does exist. In fact, this place that I'm standing on in town of Kamloops, the area has Aboriginal title, despite the fact that they have fee simple on top of that. And this is what I'm getting at in this diagram, is that Aboriginal title and treaty rights is the basic foundation title. It's the underlying title throughout Canada. And if there's any Crown and settler rights, then that rests on top of our title, and then it goes private. The courts try to say that the Aboriginal title is a burden on the Crown. We need to get rid of that concept. Legally, when you're hiring lawyers, you need to fight that, because it totally questions the human rights of us as Indigenous people. I just put this slide in there just to sort of illustrate that that's a key point that we need to deal with. Next slide. Next slide is basically what Russ talks about, the termination policy. This is what the existing land claims and self-government policies, that's what the termination policy is trying to do, is reduce Aboriginal and treaty rights and squeeze it right out of the picture. Anyways, one of the things you need to realize, next slide, is that in Canada, where there's unresolved Aboriginal title land issues, you only have two places you can go to resolve it. You can either negotiate under the extinguishment policy of the federal and provincial governments, like the BC treaty process, or you go to court. In the case of the Tsilhqot'in, they said, when we tried to negotiate with the Canadian government, they hung 6 of our chiefs. That was way back when they hung the Tsilhqot'in chiefs in the 1800s. He says, now we decided we would go to court. And so they went to court, and that's the Supreme Court of Canada recognized that they have Aboriginal title on the ground. So that's those are the two formats. And some people say, oh, we'll go just demonstrate, we'll just occupy the land, we'll go do our thing and stuff like that. Yeah, you can go do that, but sooner or later you're going to wind up going to court over that issue. Like, I know that was the case in Sun Peaks and other issues, other things, when you start doing things like blocking a mining company or doing different, blocking a pipeline or whatever have you, eventually you'll wind up in court. So it still winds up negotiate or go to court, you know, regardless of which way it is. Occupation and asserting is going to result in court action ultimately. Anyways, next slide. You know, we've had some big decisions that are in support of us. A lot of us talk about Delgamuukw in '97 and Haida in 2004. So basically what I've dealt with so far is the constitutional background for our struggle, and now this is the legal background, and we've basically been winning these cases. That's what I'm just saying. In the Tsilhqot'in case, though, you need to think about two major things, is that it's basically in two parts, the decision. You know, the decision is one is the declaration of Aboriginal title, and in that case, I'll just read what I put in here. I actually copied it from a paragraph in the case, I think 150 or something. It says, I would allow the appeal and grant the declaration of Aboriginal title over the areas at issue as requested by the Tsilhqot'in. That's what the Supreme Court of Canada said on June 26th. And this is the first part, and I got from Ken McNeil and other people opinions from, you know, academic lawyers that said that the first part, in terms of recognizing title, is a very solid legal piece of decision that you can really rely on, and it's sound based on case and precedent. Next slide. But the second part of the decision is in relationship to the application of provincial law, and it says that, I copied this, I think, from paragraph 153 of that decision. And it says, I find that consistent with the statements in Sparrow and Delgamuukw, provincial regulation of general application will apply to exercises of Aboriginal rights, including Aboriginal title land, subject to Section 35 infringement and justification framework. So they're talking about infringement. So on the one hand, they talk about recognizing Aboriginal title, and on the other hand, they talk about the provincial government's infringement. And the court totally fails in dealing with recognition of Indian law and Indigenous Peoples jurisdiction. Those are outstanding issues that still need to be dealt with, in addition to the decisions that Tsilhqot'in made. Next slide. Which basically brings you to the position where we're at right now in BC. Premier Christy Clark and her cabinet is going to meet with the First Nations Leadership Council and the Chiefs of BC on Thursday, the 11th of December, 9/11. And she's going to be laying out what the province's position is in regard to the Tsilhqot'in decision. Be interesting. I suspect what she's going to do is she's going to basically say that recognition of Aboriginal title is only with regard to the Tsilhqot'in, and that she want to limit all dialogue, negotiation about that with just them, and basically carry on business as usual with the First Nations or the Indigenous people that don't have Aboriginal title recognized on the ground. And that would be to continue the reconciliation process that they got going, which is really a way of circumventing Aboriginal title and rights, because under the reconciliation framework agreements, the province says, okay, we want this mine over here, but we want an agreement with you, but the agreement won't recognize that you have Aboriginal title to the area, but it won't extinguish it. It means that in 22 years after the mine is finished and moves out, you'll still have your Aboriginal title, but the Aboriginal title will be for the tailing ponds and for the destroyed land. And it won't be because of it won't be rich with the natural resources it has now. So the reconciliation framework is a way of leapfrogging over recognition and getting immediate consent in terms of consultation and accommodation. So I suspect she's going to do that, and I know that the federal government under the EFERD report and Ministry of Indian Affairs was talking about that, where they want to set up a federal reconciliation framework agreement, because originally the feds weren't involved in reconciliation framework agreement because they didn't want to undermine the British Columbia Treaty process. But they said that the BC Treaty process is totally ineffective to deal with the Kinder Morgan pipeline, the Gateway pipeline, and all of the mining projects, simply because the BC Treaty process has been negotiating for over 20 years, cost the Indians over $500 million, and all they got is 4 little tiny agreements. And what they're saying is that process is totally ineffective. We can't really deal with it. So we need to look for a new process. So they're looking probably for a federal process, and possibly what Christy Clark will say on Thursday is that they're going to participate in that federal reconciliation process to make a tripartite type of agreement, because I know in the EFERD report they're talking about trying to set up an energy resource tripartite committee that I guess Dave Porter and his gang would wind up being part of, and they would be trying to make quick deals with mining companies. Anyways, so that's what's going to happen. You know, the First Nations Leadership Council, for those that don't know, is basically the BC Assembly First Nations. That's Jody Wilson, Ray Bolt, and the First Nations Summit that's basically Grand Chief Ed John and the Union of BC Union Chiefs, which is basically Grand Chief Stuart Phillip. They get together. But one of the real problems with the Leadership Council is that they don't really have any, I guess, checks and balances with regard to the grassroots, and they don't really have Aboriginal title because those organizations aren't nations. They're not rightful title holders. So it becomes pretty dicey when they're the ones sitting at the table across from the Premier and negotiating the broad concepts of where we're going in terms of negotiating these issues, like in terms of the Tsilhqot'in and other things. So I think the grassroots you have to keep your ear right to the ground on this, because we can really get sidelined. Because I know at one point in time, the Leadership Council, that's when it was basically Sean Atleo, Ed John, and because Sean Atleo was AFN vice chief for BC, and Ed John and Stuart Phillip, they signed off on a deal to do a reconciliation agreement with the Recognition Act with the provincial government, with Gordon Campbell. And we fought that, and we had to defeat it. But that would have recognized that provincial crown title existed wherever Aboriginal title existed, and that would have totally undermined our position. So we need to be very cognizant of this. Anyway, so the next slide. The thing is that I just want to raise here with you guys, and just quickly, is that Canada is going to be celebrating 150 years of colonization in 2017, which is a few years from now. As that'll be 1867 to 2017 would be 150 years. And I know the government's already forking out lots of money, and they're probably going to try to get a lot of Indian people to go do Indian dancing and stuff like that around celebrating Canada being around for 150 years. But I just want to tell young activists across this country, just let's reject it. Let's fight against it. Because that's, there's nothing like 150 years. That means that you're honoring the fact that all our land is being governed by the federal provincial government. You'll be honoring the fact that they haven't really recognized Aboriginal treaty rights on the ground to change that. You'll be celebrating the fact that all we got is 0.2% of our land. That kind of thing, all those things have to fundamentally change. What we should be fighting for 2017 is to initiate a period of decolonization. Anyways, I got a bunch of slides here just of colonial oppression, and maybe you can go through them just really quickly. Now, this is just a demonstration we had in Vancouver against mining. I've put self-determination on it, but the next one is colonial oppression. Some people being arrested in BC. The next one is Irene Billy being arrested, and Barrier Lake, the young children there fighting against the just keep flipping through them. That's the Barrier Lake one, and then KI and Elsie Buck two slides there of them. But I just put those in there just basically to show you that it's really, when it comes down to hardball, they have no problem throwing us in the slammer. Just keep going to the next, till that first slide with the arrows on. Next one. Yeah, okay, that one. This basically shows my sort of visualization concept of how political and economic uncertainty is created by the fact that Aboriginal treaty rights in the courts are being recognized, and it's also undermining provincial lawmaking power. Like, for instance, with the recognition of the Tsilhqot'in Aboriginal title lands, they had a hunt out there apparently that the Tsilhqot'in really objected to. It was, I guess, some kind of trophy hunt or something like that. Anyways, the province had to send a notice out to all the rich white people that go hunt there that they couldn't get a hunting license anymore because of the title case, I guess. And also, I guess the province is removing that title territory from the computer system that allows prospectors to claim it for purposes of exploring for mines. Anyway, so that's the changes that are happening in terms of uncertainty. Now I'm going to just jump back from this economic and political uncertainty just to run quickly through the UN structure, because I know a lot of times, next slide, I know a lot of times Indigenous people talk about going to the United Nations, and you have to realize that the relationship we have with Canada has always been an international type of relationship. That's it. Next slide. Has always been an international relationship, and the United Nations has never always been really open to us. It was only in the 1970s that the doors were actually opened up at that level. Before that, Canada was always trying to claim us as a domestic problem. But through our efforts, and I know my dad had a lot to do with that in terms of the World Council of Indigenous People that was actually formed out in the Channel Territory and in Port Alberni. You know, those are institutions that help formulate these three institutions that are at the United Nations now. One is the Special Rapporteur on Indigenous Peoples, the other one is the United Nations Permanent Forum on Indigenous Issues, and one is the Expert Mechanism. So those are three institutions that have been created since that 1970 meeting. Anyways, the next slide. And the other one that has been added, and I just put this specifically here, is the United Nations Declaration, maybe next slide, is the United Nations Declaration on the Rights of Indigenous People. I'm wondering, is that the one that you got there? Is that Article 3? I can't really see. Let me see. Let me see. Oh, no, you need to go back one. No, one more. Back one more. That one, Article 3. Okay, this is from the Declaration on the Rights of Indigenous People. And I guess the thing is that you need to understand is that this makes, but it basically says in the slide, it says Indigenous people have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And so that's in the Declaration of Rights of Indigenous People, and that was passed in 2007. But this really makes it indisputable that Indigenous people are entitled to self-determination. Next slide. Because there is, Canada has always questioned whether Indigenous people have the right to self-determination, because they try to say in their arguments that Indigenous people are Canadians and our right to self-determination only exists as Canadians. You know, go back one slide. I just want to talk really quickly about these three instruments here. These are the three covenants. These are like international human rights treaties. There's actually about 9 of them, but there's 3 that actually affect Indigenous people. And these are the ones that we actually need to resort to in order to push for our right to self-determination. And these were signed on by Canada in 1966. So anyways, one is the International Covenant on Civil and Political Rights, International Covenant on Economic, Social, Cultural Rights, and the third one is the International Convention on the Elimination of All Forms of Racial Discrimination. But the first 2 there, the one in terms of civil and political rights and the one on economic, social, cultural rights, have Article 1, next slide, which basically says, next slide, basically says that all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And there's now Article 2 that talks about the substantive land and tenure issues that is significant. But one of the things is that I want to tell you is that these articles, these conventions, these international treaties were put in place to fight against colonization, to fight against the dispossession, dependency, and oppression of peoples in this world. And Canada has always been denying that we have that right. But because of Article 3 and the United Nations Declaration of Indigenous People, and because of Article 1 on the International Covenant of Civil Political Rights, and the Article 1 in the Education and Cultural Rights, which are actually identical, those two self-determination treaties, we should be entitled to that. And we can actually go to the international bodies that are responsible for, like the International Covenant on Civil and Political Rights, and demand that Canada should be dealing with this issue vis-a-vis Indigenous people. Next slide. Because one of the issues is, oh, we did that one. Okay, that one. One of the issues is that back one. One of the things in 2005, for instance, back one, in 2005, the United Nations Human Rights Committee in Geneva, Switzerland, asked Canada the following questions. It says, please provide information on the concept of self-determination as it is applied to Aboriginal peoples in Canada, including Métis people, as promised in paragraph 8 of the 5th periodic report and previous conclusion. But anyways, I think it's important to understand that they asked that, and Canada responded by saying what I told you, that that we're basically Canadians. But this was in 2005, and the other is that we're presently negotiating the issue of self-determination at the United Nations Declaration on the Rights of Indigenous Peoples negotiations, and left it at that. So basically the Human Rights Committee never really responded to that. And Canada was supposed to appear before that committee in 2010, but they didn't show up. They're scheduled to appear in July of 2015, next year. And this year they're talking about the list of questions, and they're going to talk about Canada on the 31st of October of this year, next month. So anyways, and that's an important meeting. Next slide. I actually list them in the next slide. Yeah, where they have it. Actually, the actual real date is the 31st. On that last day, as I looked at their schedule, they had it more refined than this slide. Okay, next slide. Okay, so the other thing is that I just wanted to raise another, I guess, impetus or energy source in terms of that supports why government has to deal with issues of self-determination, why they have to deal with the human rights issues of Indigenous people, and that's that is the problem of economic leverage. Because once they recognize that Aboriginal people have an underlying proprietary interest called Aboriginal title, it creates contingent liabilities. Like, for instance, in British Columbia, the British Columbia government's financial statement has to list what Aboriginal title is in terms of a liability in their financial statement of the year. And they do it under contingent liabilities. And they've had to do this ever since Delgamuukw came in, and they've been putting it in every year since then, because they have to let the people who invest in BC savings bonds know how they're dealing with the liability of Indigenous people. And this is what I tell leaders across BC. I said, I don't know how come in British Columbia we're in the financial statements of one of the richest provinces in one of the richest countries in the world, and our people are unemployed and are on welfare and they're being run down by Indian Affairs policies. I said, that has nothing to do with the fact that we don't own the land. It has to do with real poor leadership. That's what it has to do. And I stand by that. You know, I'd like to see somebody say what they're going to do, like even on September 11th when they meet with the Contingent, with Christy Clark. I'd like to see what she's going to say in terms of these contingent liabilities vis-a-vis that Aboriginal title has been found on the ground by the Tsilhqot'in people, because it has to reflect in the BC statement. Because the thing is that even though the land out there at BC is vacant, you know, like over, I think about 95% of BC is so-called unoccupied Crown land. They use that unoccupied Crown land as a revenue base in borrowing resources to build their roads, to run the government and all these things. And that's our lands. And so the thing is that now they're losing it. That changes the economic conditions, but it should also improve our long-term economic things. So there's contingent liabilities, though it might sound a little bit economic, it might sound like white man's economy stuff. It still has some real immediate proprietary and economic interests that we need to sort out, you know, and that goes also with the whole question of economic uncertainty and financial risk. And people have to realize that economic, you know, I know a lot of times when people are trying to negotiate, and I hear this amongst the people from the establishment, Indigenous organizations, talking about us working with the province to get rid of economic uncertainty. But unless that uncertainty is removed by improving the quality of life of Indigenous people, I don't agree with it. And a lot of these deals right now, these whether you call them jobs or business opportunity deals that Indian bands get with the mining companies or with pipeline companies, none of that is going to really change the quality of life of Indigenous people. The decision making has to go towards deciding issues like benefit and usage decisions. But anyways, the other thing is that I recognition of Aboriginal title creates international trade subsidies, and the other thing is that it impacts Canadian credit ratings. Next one. Anyways, I just wanted to raise those points with you. This one just deals with contingent liabilities a little more extensively. Next one. This one talks about the fact that Indigenous rights, when they're recognized, like in trade issue with export of trees and other things, that it can result in an economic subsidy. But if Canada does not recognize that Indigenous people own the trees and they sell the trees on the international marketplace, the reason, and if they have not paid Indigenous people, then that means it's subsidized. We're subsidizing the economy because those people can sell those 2x4s or those trees at less than fair market value because they haven't paid the original owners of those trees, which are us. And that goes for anything, whether it be water, whether it be minerals, or anything else. And so the thing is that recognition of our proprietary rights also includes the fact that we do have proprietary interest in existing markets that are happening. Next one. And the next one just deals with the same issue, but in NAFTA did the same thing. The other thing last thing I wanted to raise is that Standard & Poor's issue. One of the things is I have met with Standard & Poor's in New York and in Toronto, and one of the things is that in those, what we're basically, the next slide, basically the thing that we're raising in this case is that if they don't put in place financial plans and strategies to deal with Aboriginal and treaty rights, it will impact on their credit rating. And when you're talking about things like Kinder Morgan pipeline, you're talking about the Gateway pipeline, there is a lot to talk about in terms of elevating and leveraging the power of Indigenous people, not just in terms of environmental or in terms of social human rights, but also in terms of economics. So generally, that's my general talk that I wanted to give in terms of the broader picture issues that we can challenge the Canadian system with, without having to wait with trying to negotiate with the Department of Indian Affairs or with the Aboriginal Affairs provincially, and limit ourselves to the Canadian government's economic development and planned strategies, but to get outside that. And I just wanted to show that you know, when we're talking about taking action, like you should be not just think about what you're doing locally or provincially or even nationally, but think it right through to the international level, because issues like oppression, where people are put in jail, those things have to be reported to the United Nations Human Rights Committee. We have to have people that go to Geneva on October 31st of this year to talk to them. That I spent 6 months in jail, or I spent 2 months in jail fighting for stopping fracking, or what have you. And don't just leave it up to the Canadian court, because it's the pressure from that level that can create change here. If you can't get justice at home, try to get it out elsewhere, and it'll come back home. Because I know when the women were being discriminated when they married non-natives, they lost their status. When they lost at the Supreme Court of Canada, because the Indian Act ruled, they brought it to the United Nations Human Rights Committee, the very committee that I'm talking about, the one that is responsible for the International Covenant on Civil Political Rights. They brought it there, and that committee ruled that that was a racist and discriminatory piece of legislation, and that's why the Canadian government had to change that legislation. So I'm saying this because I want to let you know that that committee isn't totally toothless. It isn't just one of those committees that doesn't have the power to make these kind of changes, but it does have that power. But we need to access it, you know. And I know the AFN tries its best to do that, but it's better to come from the grassroots. It's better to come from the rightful title holders. So your strategy has to be a local to an international strategy. And meantime, I just want to put that framework there. But in the meantime, we can also talk about some of the local issues and how they interface with this concept. Anyways, that's all I have to say there, Ryan.
All right, Cookscham, Arthur. Thank you very much for that discussion. We've got about 120 people on there, I see. And so we definitely have people who are, you know, some of them are new to this, some of them are very familiar with a lot of this. And so it was great to have a good long overview of the struggle and what's been going on over the decades. And in our, you know, oral historical tradition, and for our people, and, you know, these long epic coyote stories, there are always many little stories in part of it with a lot of different lessons. And so it's really important to hear from Arthur, who's, you know, an old coyote here, and and all the work he's done over the years. Show all those little pieces right from the local level up to the international level. It's often when these court cases have come out, there's been some landmark court cases. They're never the silver bullet, and so we have to consider all these different strategies that the province and the feds also consider to make sure that we can achieve our liberation. So thank you for that, Arthur. I have a couple of questions that have been posed. Before I state those, I just want to remind all our viewers that you can post questions on the Facebook site, on YouTube, as well as on Twitter with the hashtag #TurnTheTables. So I know a lot of people are interested in what Tsilhqot'in means on the ground and how it can be leveraged. One of the first questions here is the decision of the Supreme Court really binding will the Tsilhqot'in really be allowed to use and protect these territories? What some people have been saying is that because at the end of the day it's based on Section 35 and title can be infringed upon if there is something in the national interest, does Tsilhqot'in decision really have teeth? And probably will be included in your answer is I've also understand that the decision was strong on title and not so strong on jurisdiction. Maybe you can touch on that and how on the ground decision making could roll out with the Tsilhqot'in depending on what they choose to do.
I think basically the fact that they do have Aboriginal title to an area is pretty clear, and in that sense they have a very strong legal footing to stand on. And you're right, the big part comes into that part where application of provincial law in Aboriginal title area, that's the big question mark right now. And it's one of those situations where you win 60-40 in a Supreme Court of Canada decision. You know, I sort of feel that way generally speaking. That you know we've been winning, but we haven't been winning 100%. We've been winning 60-40. In this case, they talk about the title. Sure, we beat provincial crown title, and now there's Aboriginal title, and that title is vesting in Tsilhqot'in people themselves, and not vesting in the crown, and that raises a lot of issues in terms of jurisdiction. In terms of, like, can the province really make decisions over land that actually belongs to somebody else and is not part of the crown interest? That's a big question mark, and those are issues that would have to be resolved. But the things that, in terms of jurisdiction, though, I think what has to, well, the court case is in two pieces. One is the legal piece, which is the Aboriginal title one, and the rest of it's a political decision. And in terms of political decision, it's going to still be a battle between Indigenous or Tsilhqot'in law and provincial law, you know, because one of the things you need to know that once the court recognizes title on the ground, they also have to recognize that you have the power to make law in order to manage, in order to organize, in order to you know, carry on you know, access and benefit decisions regarding that Aboriginal title land. So they have to recognize that there is Indigenous law in there, and that then if you have Indigenous law, then you need to talk about its jurisdiction vis-a-vis federal and provincial law, you know, and it really is going to depend on how much support the Tsilhqot'in can get from other Indigenous people across time to slug it out with the province on some of these jurisdictional issues. And I've said this publicly, like, they need all our support, because the government is going to try, like I said, isolate them, you know, have private negotiations and discussions with them, and try to get them to agree to a lower standard than self-determination in terms of making their decisions, and make them subject to provincial management and control. And that would be wrong. So anyway, so it is something up in the air. So it is binding in the sense that title does exist, but like any legal situation, another person can argue about jurisdiction. And one of the things about what is overridingly, that's just part of the decision where they talk about what is overridingly important for the general public, that's pretty racist, that concept. It just means that white settler rights are more valuable than Indigenous rights, you know. And then we get back to that original chart I showed where the Indigenous people think in the circle, everything needs to be harmonized between trees, plants, fish, animals, and that value system, and then you got the hierarchy of the white man value system that says no, land is resources and we need to turn it into profit. Those are two different concepts. So the thing is that I just say, it's a political fight at that point. Anyways, did I answer that question?
Yes, absolutely, and so I think also in supporting the Tsilhqot'ins in that is not just other Indigenous people, but non-Indigenous people who understand that in this world we need a different model, and so the ability for this to happen in Tsilhqot'in on their lands, to show that Indigenous values and so on can be applied in a modern context is really important as well. I think the other question that's on a lot of people's minds, of course, and ever since the decision came down, is how can the Tsilhqot'in decision be leveraged by other Indigenous nations, or even I watched another kind of webinar type thing with one of the Crown prosecutors or Crown legal people and one of the Tsilhqot'in lawyers, and they had said that the Crown's not going to want a bunch of more title cases and 336 days of testimony. What they're going to be looking for is, do other Indigenous nations have similar proof? So how do you see that playing out with the province? Because we know if the province is the interpreter of what your proof looks like, then it's not going to work out too well.
Yeah, I think one of the things is you need to step back a little bit on that issue. I think definitely, this is what I think, definitely, just right in terms of just the legal part of the argument, I think all the nations should be preparing to go to court. I mean, like, because your elders that speak the language, that know the land, and actually can be really good witnesses, like they were in the Tsilhqot'in case. A lot of them our elders are passing away, and if you lose that connection, your case is going to get weaker. So they should be thinking about going to court, anyways, to begin with. And I think the other thing what we should do immediately, especially here in British Columbia, is stop negotiating under the existing federal comprehensive land claims policy. We have to quit negotiating under the British Columbia treaty process, because as long as you're negotiating with the government under the termination plan, like Russ says, as long as you're negotiating under that, then what you're doing is you're letting out pressure out of the whole issue about whether or not the government has to change its policy on recognition. If Indigenous people right today stopped negotiating in BC, just walked away from the table and made a press conference in Vancouver, like on September 11th, and said we're not going to go back to the table, then the pressure would be on the government by industry and by the people of BC, telling them, well, how are you going to justify any the risk remedial measures like the treaty process now that they're not negotiating? Because if you look at the BC financial statements, when they talk about contingent liabilities, the first thing they say is that the majority of the Native people in BC are negotiating under the BCTC, and they're agreeing to take back Crown land, and they put out a few hectares per different band. Basically what they're saying is that the Indians are basically going to extinguish their title and get the fee simple land from the province, and that's how they eliminate the economic pressure that's put on them. And they say in relationship to some bands, they won't negotiate, and they're taking us to court, but we really don't know what the outcome is. But now they know what the outcome is. The outcome is exactly what happened in the Tsilhqot'in case. Aboriginal title has been decided on the ground. And so now the BC auditors are going to have to take that into consideration for next year's financial statement, is how they're dealing with this. That's what I call economic leverage. A lot of people don't even know that exists, but that's how the hell you really create changes, is you mess with their wallet. That's the only way that you're going to get their attention. If you just sort of try to deal nice with them, like the so-called respect and honor and all this kind of stuff, that don't work. Yeah, so that's a. Did I say so?
Okay, thanks. There was one question, maybe you answered, but wanted to say it explicitly. Someone asked, can this case be utilized in New Brunswick, where the land has never been ceded and only a peace and friendship treaty? So is there answer to that? Is go to court, or?
Yeah, basically, I think you have to take it to court. But I think one of the things is that, from what I would understand, if you never really had if you never really had a land treaty, a land cession treaty, or what do they call them? I don't know what they call them when those settlers. But anyways, it's where they say it is a land treaty, surrender treaty. Anyways, if you didn't have one of those treaties, you should be able to have Aboriginal title declared in that area. I don't think there's any issue about that. But you have to go to court to get it established. Just like that's what here in the Tsilhqot'in area, to tell you the truth, half of the Tsilhqot'in, like the northern Shuswap, are in negotiating in the British Columbia treaty process, and the southern Tsilhqot'in, we won't even sit at the same table with any goddamn white guy that wants to extinguish us. So we don't negotiate, period. And so those guys are, I think they got an offer of $18 per man, 1,000 hectares or something, territory, and they're going to have to decide to vote or not vote. And I basically told my elected chief, we should just go and for a title case up there, simply because why? Because I know some chiefs are talking about the southern Shuswap chiefs should be taking the northern Shuswap chiefs to court on whether they can extinguish title. I think that'll be a waste of legal expenses, because it's going to cost you just as much to go prove title as it is to fight amongst yourself. And if you fight amongst yourself, the white guys are just going to be laughing, and the best way to go is just go for title and seek in the legal proceedings that the vote on our treaty be held in abeyance until the legal decision on title is dealt with. But I think that's the important thing, is that we need to quit negotiating and be prepared for changing the policy from the termination plan, like Russ says, extinguishment and delegated self-government authority, like he talks about, and look at self-determination and stuff like that. So that's the way I sort of look at the shift going.
Mm-hmm. So that's something that's happening in our territory. Some bands have been negotiating treaty and some haven't, which kind of begs the question from the Tsilhqot'in decision and the ruling on collective title is maybe you can provide some clarity on or maybe people aren't familiar with the difference between whether you can go for title as a band or as a whole nation.
Well, I think one of the things is that definitely you have to go as a nation. Aboriginal title and rights is basically a collective right of the rightful title holders, not of the chiefs and councils, not of the Indian organizations like the Union of Indian Chiefs or AFN or anything like that, or the First Nations Summit. No, it's the rightful title holders collectively, which is the Tsilhqot'in people as a nation, and not as Indian bands. And I think that needs to be clear. And one of the things that you need to realize is that the government is the one that set up that BC Treaty Commission. And when they set it up, all you needed to do to enter treaty and negotiations into BC was to put a map together and a statement of intention that you're prepared to negotiate. You didn't have to do any research or anything. So a lot of these people were just putting together whatever kind of map. If you take a look at the maps on the BC government, they have a page there of all the different negotiated treaties that they got going here in BC. And you'll see it's nothing but a whole mishmash of overlap between all these different nations. And everybody's arguing with their neighbor about whether that's from my band or that other band or that nation against that nation, and it makes us look foolish. But one of the things you need to realize is Canada really uses that overlap and that division to really undermine us. I went to Washington, D.C. to listen to the Tsilhqot'in. They're a nation from Vancouver Island, and they brought a case against the Canadian government saying that fee simple land had to be negotiated in treaty, and BC and Canada was saying no, it shouldn't be, because I guess they think they have a political agreement that says that we wouldn't include it, whereas the Tsilhqot'in, in their area, all of their land had been taken over by private fee simple land, so that's how come they wanted it on the table. And but the Canada, when we went there and listened to the arguments, Canada's argument against this whole effort of Tsilhqot'in to have private land put in negotiations was that the Tsilhqot'in shouldn't be allowed to do anything with regard to governance because of the overlap between the Nanaimo Indian Band and the Tsilhqot'in Indian Band, and if the Indians are fighting amongst themselves, this international human rights body shouldn't recognize that they have any rights, because what they're going to do is create total disruption to the whole economy, and the whole country is going to go into a mess. So you can see how they use division against us. So people need to be aware of that. That's how they look at it. They look at that map of all those overlap and issues as self-defeating for us. And so anytime anybody stands up and starts talking that kind of nonsense, I just tell them the white people control the land, and you don't control the land. It's a federal provincial government that are the one claiming it. You're just, all you got to control is 0.2%. You don't got all that other land. So why do you want to get into a big fight with your neighbor, an indigenous group, when all you're going to do is guarantee the white guys are going to keep control of it, And I think that's something that is a matter of political maturity on the part of our indigenous leaders.
Yeah, I would tend to agree, and I think on the flip side too that just jumping in there and doing a title case could have really a lot of effect on unity. I know for our own nation, you get a bunch of our old elders telling oral testimony about really our laws and so on. It has a lot of ability to unite our peoples that way as well. I'll do one more question here that's a little more I guess on the ground or local, and then an international question after that. So one from YouTube says, you say correctly that even direct actions such as asserting the right to stop pipelines on traditional territory will wind up taking indigenous into court. But different type of cases than constitutional challenges. Rather, they'll be in civil and criminal injunctions and potentially various criminal charges leading from those. How does the Tsilhqot'in decision impact that dynamic? Challenge facing lower court judges in this new unprecedented situation given the Supreme Court decision?
I think you need to be a bit of a lawyer to be able to answer that really accurately. But I'll give it a political spin on some of these questions, because people need to realize that even though these are like Supreme Court of Canada decisions, there's always a political interpretation. There was a political interpretation in terms of Delgamuukw that I know they were saying, well, it just meant that the Tsilhqot'in, the Gitxsan have to go back to court. But nobody said that it was going to result in contingent liabilities being put in the financial statement. That's how I disagree with that. It has economic, political consequences regardless of what the lawyer says, or the politician, or the media person, or the expert says. There's always some additional things that are going to happen because of these cases, and I think that's the case with Tsilhqot'in. I think it's really going to put a lot of pressure on the province, but I think the real pressure, if people really want to put pressure on, like I said before, get away from the table. I think if your band and your nation is at determination tables, get them away from there. Pull away from it. Quit borrowing money. Quit paying these consultants to go sit there day after day with the federal and provincial negotiators to terminate your issues. As soon as you pull away, the latitude of creating real change in terms of access and benefits with regard to your traditional territory will increase immensely. 100%, I'll tell you right away. Because as long as they got you at the table, you're really on the table. You're not really at the table. Because as long as the policy is like what Russ said very clearly, to terminate your interests, you're finished. You're a dead duck in the water. The real decision, the real onus that should come out, I mean not onus, the real moral of the story from the Tsilhqot'in case should be is that you should stand up for your title. You should stand up, and if the policy of the Canadian government and the province of British Columbia is to modify it into extinction through the modified rights model, or non-assertion model, or through the direct extinguishment model, whatever you want to call it, just walk away from it. That's the biggest thing, and you wind up, and the leadership should get together across the province and should fight for standing together and saying the whole province is titled, and to hell with any of these efforts to reconcile. The people should walk away from the reconciliation framework agreements too. Framework agreement should be tossed in the garbage, and we just go for straight recognition of title. That's about as simple as it gets,
Mm-hmm.
Because it's a political decision at that point in time, because we know title does legally exist. It legally exists throughout our territory, because the Tsilhqot'in and the Okanagan and the Carrier and all of the tribes, we all have very definitive core areas where we have lived for 10,000 years, and sure, we might have some shared areas, but who gives a damn, Let's just agree that we all own the whole territory, and let's sit across the province with that and put that on the table. You could get rid of poverty in this province from Indigenous people within a matter of a few years. Simply because if you take a look at this province, BC is larger than California, Oregon, and Washington states combined. We only got 4.5 million people here in the whole of BC. 200,000 of them are Indigenous. How come we're the poorest people? How much Indian Reserve land do we have? In BC, it's 0.34%, a little bit better than 0.2, but we've got 0.34%. That's how come we're poor. Like, if our leadership can't stand together and say, let's get rid of poverty by standing together, let's stand together behind redefine Aboriginal title. Let's quit negotiating under the British Columbia Treaty process. Let's tell the federal government we won't deal with EFERD and the Reconciliation Framework Agreement. We want recognition on the ground. You know, once you get that, once you start accessing and have Tsilhqot'in as the model to do that, once you push that at the across the province, you get rid of poverty, because 200,000 people isn't a lot of people. You know what I mean? And we're just shooting ourselves in the foot by playing the negotiation games that we've been playing with the feds and provincial government. That's what I think, anyways.
Yeah, I think that leads or that answers another question about, you know, what do Indigenous groups now do when they're faced with leadership who don't have that vision and don't walk away? How do our people get them to walk away from these tables? And that's kind of what the hope was with this Tsilhqot'in decision, is that people would just wake up and say, okay, let's go get our land back now, which hasn't necessarily been the case. So I think what's missing is there's a lot of leadership that's stuck in the mud, and now our people have to have the faith in this Tsilhqot'in decision and doing a title case, and don't settle for leaders who do not have a vision of ending poverty in a single generation. So there's one other question here. You might see the connection with your international work. Alan Blaine said, it is possible for the Indigenous culture in Canada to take some of the reins in reviving the international culture of peace initiative that UNESCO is working on back in the 90s. The major powers choose to turn this into just a ceremonial international year in 2000, the Year of Culture and Peace. Over 800 million people are signatories to the Six Principles Declaration. This potentially could become a world movement to affirm cultural goals of self-determination and interpreting the UDHR as our supreme constitutional law. Are you able to speak to that?
What is that last part he's saying? What the model?
It says this potentially could become a world movement to affirm the cultural goals of self-determination and interpreting the UDHR as our supreme constitutional law.
Well, I think definitely. Well, I agree with any kind of involvement of Indigenous people at the human rights level, at the international level, and I think we do have a lot to contribute in terms of redefining Indigenous rights vis-a-vis settler interests. You know, and I think that's one of the issues that is at the center of this group that the former premiers, prime minister set up just recently, talking about a new relationship with Indigenous people. I'm not supporting that concept. That's the motive behind it is how do we change a relationship that hasn't been working. Is really what we're talking about, and I think Indigenous people have to really think at that level, like the issue of our values and linkages to our land is really important in terms of berry picking, hunting, forestry, in terms of our air. We're the only ones that really question the corporate concept of land as just a basic resource, and I seen that in the sacred fire that was set up by Mount Poly mining spill, where I guess the sacred fire became the venue through which the local non-native people who lived in the area could go to in order to express their real gut reaction to what happened to their water, what happened to their local area in terms of that mining spill. because the province's idea of their sacred fire was to give the local two Indian bands $200,000 each for past and future damages regarding that spill, and basically have them locked into the provincial government's disaster, I guess, management plan. And we need to be. I don't accept that. I don't think that our elected system should go along with that. I don't think Indigenous go along with that. Period. And that's one of the things that what I'm saying about models, when people are talking about role models, and the role model is to be honest to your values, honest to our traditional values about working with the land and not using it as a resource, and putting that forward. And that shows respect in terms of talking to the non-Indigenous people and to the government, because what we're doing is an equation, a concept that has been totally missing from the Eurocentric concept of economy, because the Eurocentric concept of economy is just to make money at any price, and we need to educate them that that's not the way you put. That's not how you leave the world for future generations, is with that concept. And so that's what I'm trying to raise, is that Indigenous people sometimes, like one of the things that colonization creates is, in the settlers, they develop this fake or false sense of superiority, because, okay, we can produce an all-terrain vehicle, or we can produce a computer, or we can produce, they get into all this kind of, oh, let's give us lots of points for that. They don't talk about the damage that those things cause in terms of environmental stuff, but they say at least we could produce that at the end. Sometimes you don't argue with that. But what I'm saying is that Indigenous people have always looked at sustainability. Even like when the year, and then what happens, I guess, when Indigenous is that we have a real false sense of inferiority, and it's because of that inferiority that we don't, I think, fully respect and represent our relationship in terms of the land, and to explain more fully what the concept of things like the Mount Holly mine would be, because at the same time as Imperial Metal is absolutely doing nothing in terms of repairing the damage caused at Mount Holly, they're asking, the Tsilhqot'in people are asking us, Tsilhqot'in people, to agree to a new mine at Ruddock Creek, and I know before the spill, a number of bands, I think Adams Lake was one of them, that actually agreed with the mine, going in. But I think everybody's backtracked on that right now, because really the mining companies in our area is not really one of the smartest things to do if you want to get re-elected. So the thing is that but Indigenous people need to be more assertive. So the role model, I think Indigenous people, not only here in Canada but around the world, have to do is to keep that linkage together, because it's through this added Indigenous component of value systems that we're going to be able to deal with global warming, that we're going to be able to deal with all the big mega problems that the Eurocentric concept of economy has created. So yeah, I agree with this guy that human rights will play a role in that, but it's all part and parcel of trying to rearrange people's thinking about what is good and what is bad in terms of our relationship to our land, to our territory. And I think that's what Indigenous people have a new, fresh look at that and stand up for that right across the country, right around the world. Kind of thing.
Absolutely. I think that it leads into this, probably one of our last questions here, and also reminds you when I was up at the Tsilhqot'in and medical camp at Mount Polly, and Chief Roger William was up there, and he had said when talking about the islands of fee simple land within the tidal area where non-native people lived, and he was stating that he wants them regarding the relationship to understand that they're going to do things better, and so that there shouldn't be fear about it, because Aboriginal title means a better world, really, a sustainable way of living that's better for all of our people and all of our grandchildren and great grandchildren. So that leads into this question. If you had any recommendations for non-Indigenous communities to support the William decision momentum, municipal tiers are not happy about what the province is doing, either particularly with respect to water and air quality. And as you mentioned, there is a kind of an inferiority of our people, and so one of those things is for non-native people to stand our people up and say, we do have the answers, and to learn about them and support that way. So if you have any recommendations of what non-Indigenous people individually and collectively in their communities can do to support the process, we can let the viewers know.
Well, I think one of the things that non-Indigenous people need to do, it isn't. I don't think it's really one of the things that cannot be done. It's one of the things that has to be done, and that is that you have to be pretty clear to the provincial government and the federal government that they have to recognize that Aboriginal title does exist on the ground. Right now, big industry and big government is basically in charge of all of the access and benefit decisions regarding that 99.8% of this country. And we are getting into some pretty serious trouble and on the carbon issue. For instance, like tar sands of Alberta. Wow, that's crazy. I've heard that just from the fumes, they've basically killed all the mosquitoes. I know people don't like mosquitoes, but actually they're part of nature, and you're supposed to like them. But anyways, but the whole whatever they're disrupting in terms of the soil is generating all kinds of problems that are totally irreparable. And the way it is right now, the BC, Alberta and the federal government sort of got that all locked up tighter than a drum, that those decisions are legitimate. And when it comes to, and they're sort of trying to skirt around the Tsilhqot'in decision that it didn't deal with water. But I think water is attached to the land, and there's really no real difference between them. And politically, we need to fight for that. And the only way you got a second chance in terms of rethinking Gateway right now is if Indigenous people decided to legally challenge it in terms of going to court on that, and make the changes needed to that decision, reverse it, reject it. Those are what I'm just saying is that changes the dynamic of that federal provincial government just being the mutual and exclusive decision makers. Because what it does is it goes to that second graph that I had there, where the red part is a lot bigger because that's constitutionally how that works, and that's what I mean when we talk about recognition of Aboriginal and treaty rights, is that all of a sudden you add this sort of different value system in, because it's the indigenous sustainable concept that will be in the indigenous form of government. That's because you'd have to have your elders who would be responsible for making this final decision along with their people on these concepts of whether we're going to agree to pipelines or not agree to pipelines. And if we agree to something, then we better know exactly what the access issues are and what the benefit issues are going to be on every one of those things. And they must be in line with our general indigenous sustainable concepts of dealing with land. And so that's the thing, is that I think recognition for non-natives means like what actually happened at the Sacred Fire, is where indigenous people were allowed to interface with people who actually own the land, to be able to talk to us, who are indigenous people, about what their concerns are, because they're actually the ones living out there in likely, the ones that are actually impacted by the poison that's being put in their water. So the thing is that those are things that I think people have to understand. I know that's especially true when it comes to things like, should we be shipping water to the United States? I know some people were concerned about that. I told them the only way you can stop that is to recognize that water is an Aboriginal or treaty right, and that we're the ones that will have to decide whether that's going to be possible. Some people might not agree that indigenous people should do that, but I think it's better to have more people in the decision making on some of those fundamental issues, like areas, the decisions that are going to impact global warming, like the tar sands, or like the shipping water in the United States or stuff like that. People should have more people make those decisions, and one of the people that have to be totally included in that decision making process are indigenous people. That's definitely the road we have to really need to stand strong on, and we need to be convincing that's it's no use. Like, I know so many Native people who have inferiority complex and sort of say, let's respect, but they have respect with cap in hand kind of respect. We don't need that kind of respect. We need to have respect based upon honesty and integrity regarding our values. We have to stand up for our values, because it's those values that will make Canada a better place. That's make the Canada a better place, bringing back those traditional based values and giving them credibility in decision making. That's what I sort of think anyways.
Okay, well, we're just about ready to wrap it up here, but I do want to be cognizant of the fact that we're not just BCers here that are non-treaty, and we talked about out east where they have peace and friendship treaties, but I wonder if you could comment on our numbered treaty brothers and sisters, about so I'll just read the question out here. It says, I know we are talking here about Aboriginal title, but for these nations which have a treaty, and because of that they are oppressed by colonial interpretations of the treaties, as with the recent SCC decision on Tsilhqot'in, Treaty 3, what is the path ahead for them? If you can comment on that, and then we'll wrap it up.
Yeah, I think in terms of the Tsilhqot'in decision, you have to appeal that to the United Nations Human Rights Committee. Definitely, that decision is totally wrong. It's totally an offense to the right of the indigenous people under the treaty and under all treaties to be saddled with that kind of opinion. It's just as that opinion was just as bad as the opinion that the Supreme Court of Canada made when it validated discrimination against women. You know what I mean? What they're doing here is they're validating that the province has control over the lives of Indigenous people. You know, the fact that the Department of Indian Affairs has a registration list for Indian people, and I'm one of those so-called Indian people, means that I'm colonized. That whole decision of Tsilhqot'in is a colonized decision that is an offense to the human rights, not just the Indigenous people impacted by that treaty, but by Indigenous people and people in general in Canada. And it has to be appealed, you know, like it's regardless of what happens. You know, I was an elected chief for 8 years. I was a tribal chairman for 6 years, head of the Interior Alliance. I was on joint committees with Phil Fontaine on comp claims issues. My dad was a president of the National Brotherhood. And so I've heard treaty, non-treaty, you know, pre-Confederation treaty, and now I hear modern treaty. All of these agreements with the government of Canada and us with Aboriginal title. I just want to tell you that regardless of what you are, in that mishmash of agreements or non-agreements, the government doesn't recognize their human rights under any of them. You know, I don't care if it's a pre-Confederation treaty, they broke it. Number treaty, they broke it. You know, even the modern treaties like the James Bay Cree and the ones that just signed these agreements with the government just over the last couple of years, even they have an organization that they formed in order to try and get their agreements agreed to. You know, so and they're in a bad shape as we are. So we're all messed up with a government that is just committed to its own self-interest, doesn't have any interest in working with Indigenous people, breaking agreements all over the sun. And that's how come I say, if you got that kind of self-interested group, and that's how come that First Ministers Conference failed too, is because of their own self-interest. They didn't want to break up and share power with Indigenous people, the federal or provincial government. Therefore, they wanted to leave it up to the courts. And so the reason they did that is because of their own self-interest. So the thing is that if you got a self-interested settler government and settler courts, and they're just going to keep on patting themselves on the back on exploiting our land without our ability to protect it, then we need to go to one higher level. And see, like that Article 1 in the International Covenant on Civil and Political Rights, for instance, Canada signed on and said they were going to implement that domestically. So they're supposed to be implementing it vis-a-vis in regard to Aboriginal title, in regard to treaties, both post-Confederation, pre-Confederation, and modern treaties. They're supposed to be implementing it all across the board. And the Supreme Court of Canada should be held accountable to implementing the right to self-determination of Indigenous people. And when they don't do it, then we have to bring them to the international United Nations Human Rights Committee into Geneva, Switzerland, and demand that it be dealt with in terms of Canada's periodic report. You know, so see, like Canada has to in 2015. This is what they have to do. They have to go to the United Nations and give their report about how they're implementing that International Covenant on Civil and Political Rights inside Canada. Okay? So they need to explain to the UN committee how they're implementing Article 1. And if you take a look at their report, it's on the internet, you'll notice that they don't even talk about Article 1. But that doesn't mean they're not supposed to talk about it. They're supposed to talk about every one of the provisions in that international human rights treaty and how they're applying it. And then they need to say how they're applying it with regard to the people from Tsilhqot'in case, the ones with the treaties, whether they have Aboriginal title, they're supposed to be talking about, and you know, they have to justify why they oppress the people from Tsilhqot'in and all over the place. That's the place where you go tell the world about how Canada is violating Indigenous peoples' human rights by not recognizing that we have a right to self-determination. That you know, because that decision that is totally a human rights violation according to Article 1 of the International Covenant on Civil Political Rights. Those judges at the Supreme Court of Canada do not have the human right to be able to make that kind of decision. Yet they'll make that kind of decision because they're bound and being corrupted by the colonial doctrines of discovery. The whole issue that Canada has the right to dispossess, make us dependent, and has the right to oppress us, Indigenous people. You know, that's what we need to put on the tail of Sharon McLaughlin, or whatever her name is, the Chief Justice of Canada, and let that bell ring on her tail, you know. And the same with all the judges of the Supreme Court. When they start making bad decisions like that, we need to make them internationally known as rogue and racist type judicial decision makers, because those are wrong, definitely wrong. So I think we're all on one page on this. You know, if one group, let's say the pre-Confederation treaties all had their land recognized, and the rest of us didn't, then I'll say there is a difference. You know, since none of us got any of our land recognized, we're all the same. We're all equal. We're all common brothers and sisters in the struggle. You know, and let's just keep it together. Let's just push it up to that level. Let's go to the UN on October 31st. Let us say Canada has to answer in regard to Article 1. You identified a bunch of issues here. Those are the kind of issues that we need to bring before the UN. Anyways, that's all I have to say about that.
Great. Okay, well, I think we'll start wrapping it up there. We'll have this webinar available online in less than an hour, up on YouTube and I Don't Know More website. We'll also post the slides from the presentation up on the Facebook site. Any questions that went unanswered, we'll do our best to answer those in a timely manner on the Facebook page, and hope that you all will keep the conversation going on that Facebook page, and you can continue to ask questions and discuss there. Arthur, do you have any final words?
No, that's no. I'd just like to thank everybody for joining us, and especially thank the Idle No More team that sort of got this thing up and running. I think this is a good opportunity for the grassroots across this country to start coming to some common understanding across this territory and taking action. And I think Idle No More is the right body to do that. I just want to say that also I do all of my work here on a voluntary basis, and the reason I say that is that means I am a lot more freer to be able to express the opinions that I express. And I know I upset sometimes people from establishment organizations, but that's not my purpose. My purpose is to try and ensure that we as Indigenous people achieve self-determination, that we do have our sovereignty recognized on the land. And I think funding is a big issue right across the country. I know Idle No More is lots of volunteers across the country, and you're volunteers because basically the work you do is totally priceless. You know, there's just no way that we can afford to pay you for that great service. But the thing is that and I know that that's the level of organization we've come back to. I think all of this stuff about getting paid big bucks to be part of political organizations has run its course. I know the government's cutting them back, and there ain't too many of us willing to run out and start picketing the government to give our organizations more money simply because we don't get a lot of product for the buck the government gives them. In fact, I think it's a big contradiction that the rednecks are the ones that are exposing the people who are making money off taxpayers, they say. Because those are the guys that are actually undermining, the ones that actually make all the real big money, are the ones that are actually undermining our rights. And we have to think about, if we want a real strong political organization in this country, we need to fund our political leaders ourselves. I'm not talking about programs and services. I'm talking about political leadership, whether they're the president of the Union of BC Indian Chiefs or the national chief of the Assembly First Nation. That money should come from the people. It shouldn't come from the Canadian government. And you know, there's things like education directors and stuff like that that should be paid by the government, because, like my dad said, well, they stole the land. They got 99.8% of the land. If they don't turn back at least 51% of it, then they should be paying for that. You know, so the thing is that that's the way I sort of look at it. So the thing is that, but political money is a little different. That's the head guy that's leading this. He's the guy that should be paid by the people, and if the people don't want to pay him, then he should move on. But the thing is that that's the kind of thing we have to talk about, hard nuts and bolts and organization. But anyways, I think Idle No More is a good grassroots organization. It's the same kind of thing my dad used to do in the 1950s and 60s. I run into people who said, you know, I gave money for your dad to go to Ottawa, or I gave money for him to buy a suit and stuff like that. I run into elders from around BC. They tell me this, you know, because that's how leaders in those days used to organize. All the funding that went into these organizations went into these organizations way back in the 1970s. We should have questioned that money after 5 years, because within that 5 years of when that money was first given, that was when the red paper was put out by Indian Association of Alberta and the Union. All the organizations across BC, Canada, you put in organization. The government rejected them, and nobody said, well, what should we do now? We should have rejected the money, and we should have went back to the grassroots for support. And we never did that. We just kept on taking it year after year after year, decade after decade. And now we're stuck where we are, where our leader organizations have moved away from what the grassroots want. And the Idle No More is kind of cool in the sense that it's gone back to that older stage and building back up from the ground up. And I think, you know, I think there's promise there. That gives me hope as an old dude that's looks champ.
Great stuff, Arthur. And yes, thank all those people doing all the volunteer work. All that work is really important. The funding issue is a whole nother can of worms, but it will need to be addressed at some point. But I think the takeaway, or part of the takeaway from this talk about Tsilhqot'in and so on, is that it has it's created hope. And even though there's been a lot of volunteer hours and people have worked whole lifetimes on this, you know, it says this could be the home stretch if we want it to be the home stretch. And so there's a need to keep on pushing and have an uncompromising vision of freedom and self-determination, and don't settle for leadership that doesn't also hold this. Just lead the way, come together, and make the real change for our future generations. Not just in theory, we can do it now. So thank you everyone for tuning in. So we'll wrap it up there. Tsilhqot'in.